Okay, I got it.
Yes, sir. All right, go ahead, sir.
Okay. This is the first month, 20th day, 1508 of the Aboriginal calendar, and April 9th, 2022 of the Gregorian calendar. We had a 3 out of 4 vote against the motion for recusal in favor of the prosecution's response, which, you know, it kind of gave a partial, I would say, acceptance of Kenway, the defendant's motion. Headquarters requests that Arkan Shabazz sit in bench present at all hearings with power to direct, speak for, and participate in proceedings, but voting in the case of Arkan be abstained to avoid any potential issues with the verdict. And then as far as Minister Trezell, he's remaining on the bench, and he still has all adjudication powers, yes, any Jail Society member would have. So we can go ahead. Is the plea bargain still on the table, or is that off? Or do we want to go over that?
I mean, we can start with an opening statement from both sides, and then.
Okay.
Okay, should I start first?
Yes, sir.
Yes.
Okay. In this matter, we have what I have deemed after review a very simple issue. The first issue is we are building a government. Kenway is a part of it. Love She is a part of it. Karen is a part of it. Yasmine, myself, everybody's a part of it. And so in this process, we're going to have ups and downs. We're going to have mistakes. We're going to have errors. We're going to have the opportunity to do what we're doing now is resolve it. And my spirit is the spirit of resolution, so that the people who believe that they were injured are made whole. If Kenway believes he's injured, he's made whole. If he made mistakes, we can fix him. And so that is why my ultimate desire was to deal with the plea bargain, which is more of an arbitration, because it will spare a lot of what could potentially happen. And the potential is simple. If people think that they're injured, then they're going to feel, if they have proof, that ARNA is bullshit, that the jurists are wacky and wild and irresponsible and disorganized and not carrying out their duty, people stop speaking. People stop being family. So I'm not approaching this like a regular court case in the other world that we come from. I'm approaching this like family, and I understand that people make mistakes. And so my position currently is that the defendant committed every action that we stated he committed, and that for the most part, he has been very defensive in some places where he should not be. And I'm going to use the discovery that he provided, the interrogation and the interrogation of my clients to close the matter, present the evidence so that the Drill Society can make a determination. That's my duty. These are all my brothers and sisters. I love them regardless of what somebody said about them or what they did. And I want this to be resolved so that everybody at the end can say, okay, that was fair. Let's start back over and let's try to do this better. So that's pretty much all I have to say in the opening.
All right, thank you. Let's go ahead and give the opening statement to the defendant.
Greetings. Yes, so my statement will essentially be essentially what was given in the answers, and my my recent answers within the discovery, things of that nature. My perspective of it is, I'm willing to, of course, fix any damages been done, or even if it was in regards of miscommunications between parties that that I've admitted to, that needs remedy, because they didn't get, there was services were stopped, things were were at a dead stop. Speaking mainly on Karen, the plaintiff, the plaintiff in this case. In regards to Yasmine Shia Ali, there are factors there that point to the point, point that there was some deception there, and that my name and my business took a hit because of that. So on Yasmine Shia Ali's part, I want verification that what she told the prosecution was actually done, and that nothing was deceived or lied upon onto the prosecutor about me that ended up injuring me. Because if I signed a plea deal where that was the occurrence, then that wouldn't be justice. And in regards of Love She, the situation with her, in her case and her positioning is that I was supposed to do something that there was no protocol for to do, or no open lesson on that in specificity. But then on the aspect that the case of bribery that she admittedly committed against me. So in the case where there's a plea deal, where in the aspect of I'll be giving the apologies and the onus is be given on me, when it looks to be that these transgressions were put upon me, my name and my business, should be dealt with, and in that aspect. Now, yeah, that's my position. So if there's any information that contradicts that information, definitely willing to hear.
Okay. Thank you for your opening statement, defendant. Let's go ahead and the presentment of prosecutor and the examination and things of that nature. So go ahead.
Okay, so what time period we dealing with right here? And like is this my main prosecution, or is this what's happening? I just try to get a little structure so I stay in tune with everything.
Okay, so at first I had the plea bargain overview on the table, but it seems like Minister Kenway likely not going to accept that. So I mean, I had it for 20 minutes so we can overview it if he had any questions.
Well, my position, just to be clear, if there's information that contradicts anything that I stated, like I'm all ears. So if there's evidence that Yasmine Shia Ali did reach out to me, like she told headquarters and the chief executive that she did reach out to me and I did not respond, and that she was told again to reach out to me again via any way, because there's no records of it. There's no records on my end. I'll say on my end. There's no records of it via email, via DM. I've sent the last correspondence I've got from Yasmine Shia Ali to my, I sent that in. I don't know if it was in the answer to the complaint or what have you. I might have sent it on several documents. I can show it here again. But there wasn't any correspondence. So if there was, and I missed it, then aspects of the plea deal would be, I'd be willing to consider. But there would have to be some edits, because the way I'm looking at the case with Love She, that there was admittance of bribery occurring. So I would, like, edits on that, if that's where we're at. So
All right, so I'm not going to edit it, because when Yasmine Shia Ali, she never came back to me and said, I talked to Ken, I sent Ken a text, I call Ken. I did not have a contract or require her to contact you. It was a statement of kind of like, reach out to the brother and see what's going on. She is not legally required to reach out to you after she starts and initiates her process. That's actually your responsibility as a jurist. And so she never lied. She never said, hey, Chief, I reached out to Ken and he didn't reach out back to me. So I never stated that. If I stated that in a document, you need to highlight where I stated that. If she stated that, you need to say where she stated that. She came back and said, Ken's not responding again. She initially came to me and said, I did my nationality in such and such time. He hasn't talked to me. I was like, that's unusual. I said, well, reach out to him and see what happened. She came back to me the second time and said, he still has not contacted me. She never said anything of that nature. We never put anything in a document, so I don't even know where that's coming from. Second, Love She never admitted to bribery. She was using a rhetorical conversation saying, okay, if I bribed you, she was trying, if you pay attention, and I've talked to her, so I know what she was trying to do. She was trying to show you that if she committed something that was a breach, she was willing to fess up to it. And she was kindly giving you a gesture saying you should do the same. She did never confessed, I bribed Ken and I confessed on the record. That's not what happened. And we can review the video to see that. As to there being no protocol on tax exempt certificates for tribal LLC, that is blatantly false. And this is why I went to the file to show that document was there, to show that we have a standard LLC, a tribal LLC, and the difference between the two. And the entire time, as many times as me and you talk, off record or on record, it would have been simply enough to send one text. You send me text over a whole bunch of other things. You could have said, I don't know this protocol. I'm unaware. Instead of going at her, which she's not a jurist, instead of going to all the other jurors who you may or may not have, could have said, Chief, do we do da-da-da? Sure we do. Here it is in your jurist file that's on Aboriginal University that you were supposed to download to keep as the 7 types of businesses that we do. So in that case, she didn't bribe you. And even if you were unaware of a protocol, you had to change a communication to get it. So no, I'm not changing that either. And as far as Karen, you lied in respect directly to a client saying you could do indigenous trademarks, which is false, blatantly false. You can't do any indigenous trademarks. And we can pull that email up with your exact words and what you say, which I already did for the record before. And secondly, you haven't given her a refund yet. No one's stopping you from giving her a refund. You could have did that out of a good gesture. And then you also, she asked for the refund and you stated on record that she didn't ask for a refund. And then we found out that she did ask for a refund. So you're not keeping up with the communications of your client. I don't care if y'all text most of the time or email most of the time. You were responding to some emails, you were responding to some texts. And this is an incident that, by the way, that's over a year old. So even in preparation for the court case, you did not take the due diligence to say, let me go back and look at all my records with her so I can be ready and prepared for prosecution and defense. So that shows the major problem here that we are witnessing is that you are disorganized. The plea deal was an olive branch, an opportunity to fix everyone's problems, to monitor your activity over a prescribed period of time so that you don't have to stop jury services, and to make sure that you're keeping up with everything that's going on. And you have not been. And so I'm not changing the plea deal. The plea deal is still on the record and it's offered if you're willing to take it because my clients are okay with it. That's the only reason it's still on the table. But if you're not willing to go along with it and you think that your points that you just made are valid, I'll go through this prosecution to prove that everything that you just said is invalid and that you committed every infraction on these particular people and that you should receive the full punishment, whatever the Jewel Society decides in this case. So no, I'm not changing it. I'm not editing it. It was a good gesture. It was a good gesture to resolve the problem. And if we can't resolve it at that level, that's telling me a lot about you not wanting to face what you have done to these particular people.
May I respond, or should we go to the next? Okay.
I think we got a 20-minute period. So yeah, we got.
Okay, cool. So, in light of what was just stated, and I'm gonna start with Karen again. In regards of Karen, one, I've never stated that I myself can do that process. I was working with a jurist who stated he knew that process. He knew a other than U.S. jurisdiction process for trademarking, where I was working with it to be able to accomplish that.
Did you tell Karen that? Is that what you told Karen?
It may be in the records. I can check the records before we're off.
That's important.
Okay. Yeah, I can check the records because
what exactly you told Karen is important.
Okay, absolutely. So that's the aspect there of being able to do trademark. Now, even in the regards of being able to do trademarks in general, like I mentioned, I believe in the first hearing, I have experience doing U.S. trademarks in the U.S. jurisdiction. Well, as soon as I found out that there was, access to the way of doing it a different way, that's when I let her know you have a different way to do that. The reason it wasn't done is because there was information in the intake that wasn't filled out for why she said she would get it done. That's wherein the email that I missed that after she said she would get the intake done, she sent it on a different modality of messaging via email that she wanted a refund. I did miss that. So I'll take the brunt of that. But in general, that's what I was waiting on. So just to kind of, get the information on that. That's the case. I didn't think it would be proper to start doing paybacks, immediately, even though I do agree that she should get a refund until till we were done with everything here. So, until everything was concrete. So, that was just my mindset. Give you the mindset with that process there. So that was stated. Now, in regards of Yasmine Ali, regardless of whether she literally, and I'll pull up the information on regards to the messages to make sure I'm clear on that. Regardless if she said that she was waiting on me, or that she confirmed, hey, I tried to reach out to him, I didn't get him, can you do my documents, what have you. The point of it is that she hadn't fully paid, yet she had somehow, and it seems it was brought upon in regards of deception, managed to get nationality documents done without paying headquarters the full amount, without paying her fees and her IDs. So it is protocol in the government of ARNA that your dues is $720 for you to become a national. You pay that to either juror services, you pay that to the headquarters. If you don't do that, then you don't get your full. That's not, you haven't completed the terms becoming a national in ARNA. She hadn't done that, and that's on the record. So in some way in that scheme of, regardless of what was said and who said it or who was expected, there was manipulation done to get that done, to get her process done without paying the full amount, at least to me. Now, if she paid something else to headquarters, which it seemed like that wasn't the case, because I paid for, that wasn't done. So there was some form of manipulation or some form of deception that was done in that aspect, to my knowledge right now, unless I've been proven wrong. But I paid for her, and that's on the record. I showed that in the first hearing. I can show it up again. I paid her dues and her jurist fees for her before she got her, after she got her documents, after she got her IDs. So information on the record there. Let me know if I'm wrong with it. If I'm incorrect, I paid for her. So
she paid for it, bro. That's her money.
She paid $500.
We're at we got 1 minute and 11 seconds.
Bro, that's her money. That ain't your money.
Minister Cooper, could you send out another?
But is dues $510 or $720?
Dues are $360.
First time for first year national and juris fees payment 720, correct?
Absolutely
become-
correct.
Okay, so if she only paid $510 on the record,
On the record, she paid $510. That's correct.
right? Now, was that the full amount that she was supposed to be paying?
She
for
wasn't
her?
even aware of the full amount. You got to go back to what you stated before on record and what you both stated before on record. She paid you $360 because she thought that was the fee. And according to what was stated, and I have to go back, that was communicated directly from you, according to what she said.
We have less
And
than
then she came back and she provided $150. And that was because now she's trying to scramble to get the other amount that was not communicated to her.